House Committee on Natural Resources and Tourism will come to order. Would the clerk please take attendance?
Chair Martin.
Here.
Representative St. Germain.
Here.
Vanderwall.
Present.
Outman.
Here.
Hoadley.
Here.
Johnson.
Here.
Preston.
Yep.
Bonak.
Here.
Fairbairn.
Here.
Wertz.
Here.
McFall.
Here.
Scott.
Present.
Weiss.
Here.
Arbit. Foreman.
Present.
Myers Phillips.
Here.
Wooden.
Here.
Mr. Chair, you do have a quorum.
Thank you. Representative Outman makes a motion to approve the minutes of our previous meeting. The minutes are approved by unanimous consent. We heard testimony last week on House Bills 4694 and 95, sponsored by Representative Markkanen. Deals with Recreational Authorities Act up in the tip of the peninsula. We also have House Bill 4798, which is a technical bill that simply updates reference in relation to the other two bills. You shall have a copy of that. Deals with just the where the property tax for the separate municipalities where they touch. Breaks out the municipalities. We'll be moving 4798 today as well. Any final questions from committee members on the Markkanen bills? I'd like to read in two cards before we take the amendment. We have not wishing to speak, supporting the bill, Kelly Ryan from U.S. Endowment for Forestry and Communities. Not wishing to speak, neutral, Emily Smith, Michigan Environmental Council. We do have the amendment. Is this? We do have an amendment for us on House Bill 4694 at the request of Treasury. This amendment clarifies the payment in lieu of taxes process. Representative St. Germain makes a motion to adopt the amendment. The clerk will take the roll.
On the motion to adopt the amendment, Chair Martin.
Yes.
Representative St. Germain.
Yes.
Vanderwall.
Yes.
Outman.
Yes.
Hoadley.
Yes.
Johnson.
Yes.
Preston.
Yes.
Bonak.
Yes.
Fairbairn.
Yes.
Wertz.
Yes.
McFall.
Yes.
Scott.
Yes.
Weiss.
Yes.
Arbit. Foreman.
Yes.
Myers Phillips.
Yes.
Wooden.
Yes.
Mr. Chair, you have 16 yeas, 0 nays, and 0 pass. The motion does prevail.
Thank you. Now, Representative St. Germain makes a motion to report House Bill 4694 as amendment as a new substitute. The clerk will take the roll.
On the motion to report, Chair Martin.
Yes.
Representative St. Germain.
Yes.
Vanderwall.
Yes.
Outman.
Yes.
Hoadley.
Yes.
Johnson.
Yes.
Preston.
Yes.
Bonak.
Yes.
Fairbairn.
Yes.
Wertz.
Yes.
McFall.
Yes.
Scott.
Yes.
Weiss.
Yes.
Arbit. Foreman.
Yes.
Myers Phillips.
Yes.
Wooden.
Yes.
Mr. Chair, you have 15 yeas, 0 nays, and 1 pass. With that, the motion does prevail.
House Bill 4694 is reported as amendment as a new substitute. Representative Fairbairn makes a motion to report House Bill 4695 with a recommendation. The clerk will take a roll.
On the motion to report, Chair Martin.
Yes.
Representative St. Germain.
Yes.
Vanderwall.
Yes.
Outman.
Yes.
Hoadley.
Yes.
Johnson.
Yes.
Preston.
Yes.
Bonak.
Yes.
Fairbairn.
Yes.
Wertz.
Yes.
McFall.
Yes.
Scott.
Yes.
Weiss.
Yes.
Arbit. Foreman.
Yes.
Myers Phillips.
Yes.
Wooden.
Yes.
Mr. Chair, you have 15 yeas, 0 nays, and 1 pass. The motion does prevail.
House Bill 4695 is reported with a recommendation. Again, Rep. Fairbairn makes a motion to report House Bill 4798 with a recommendation. The clerk will take the roll.
On the motion to report, Chair Martin.
Yes.
Representative St. Germain.
Yes.
Vanderwall.
Yes.
Outman.
Yes.
Hoadley.
Yes.
Johnson.
Yes.
Preston.
Yes.
Bonak.
Yes.
Fairbairn.
Yes.
Wertz.
Yes.
McFall.
Yes.
Scott.
Yes.
Weiss.
Yes.
Arbit. Foreman.
Yes.
Myers Phillips.
Yes.
Wooden.
Yes.
Mr. Chair, you have 15 yeas, 0 nays, and 1 pass. The motion does prevail.
House Bill 4798 is reported with a recommendation. We heard testimony last week on House Bills 4672 and 4673, sponsored by Representative Markkanen and Representative Steele, which exempts Gold Star families from paying for a recreation passport. Any final questions from the committee members? Rep. Hoadley makes a motion to report House Bill 4672 with a recommendation.
On the motion to report, Chair Martin,
Yes.
Representative St. Germain,
Yes.
Vanderwall,
Yes.
Outman,
Yes.
Hoadley,
Yes.
Johnson,
Yes.
Preston,
Yes.
Bonak,
Yes.
Fairbairn,
Yes.
Wertz,
Yes.
McFall,
Yes.
Scott,
Yes.
Weiss,
Yes.
Arbit, Foreman,
Yes.
Myers Phillips,
Yes.
Wooden.
Yes.
Mr. Chair, you have 15 yeas, 0 nays, and 1 pass. The motion does prevail.
House Bill 4672 is reported with recommendation. Now Representative Hoadley makes a motion to report House Bill 4673 with recommendation. The clerk will take the roll.
On the motion to report, Chair Martin.
Yes.
Representative St. Germain.
Yes.
Vanderwall,
Yes.
Outman,
Yes.
Hoadley,
Yes.
Johnson.
Yes.
Preston.
Yes.
Bonak,
Yes.
Fairbairn.
Yes.
Wertz,
Yes.
McFall,
Yes.
Scott,
Yes.
Weiss,
Yes.
Arbit, Foreman,
Yes.
Myers Phillips,
Yes.
Wooden.
Yes.
Mr. Chair, you have 15 yeas, 0 nays, and 1 pass. The motion does prevail.
House Bill 4673 is reported with recommendation. That was pleasurable. We'll now take up House Bill 4411, sponsored by Representative Phil Green, which amends the littering law to provide for cost recovery for removal of damaged vehicles and debris. Representative Green, please come and give us an overview of your bill.
Thank you, Mr. Chair, and thank you, esteemed members of the... Well, I wanted to make a good impression, but thank you all for allowing me to present this bill. House Bill 4411 is, in essence, a cleanup bill from some unintended consequences from the littering law. In short, under MCL 257.618A5 and 7 and MCL 324.89022, a company that removes a vehicle, tows a vehicle after an accident, is also required to remove all injurious substances. An injurious substance is not defined inside of our law. It is defined amongst the EPA and EGLE. And so as our regulatory burdens and environmental laws and regulations increase, thus now we have a situation where a spill of diesel fuel or a spill of radiator fluid or whatever now falls under EGLE and EPA to have that mitigated. So a towing company that removes a vehicle is mandated by law to also clean all of that stuff up. This bill does not deal with the cost to clean it up. This bill does not deal with the process post a claim is made. What this bill does is cleans up the littering law that says that when there is litter or a situation, the owner of the road is responsible for remove, or the owner of the property is responsible. In an accident, the owner of the property that is affected is our local roads, either MDOT, the county roads, townships, the municipality. And so the way that this was written did not take into account that concept of an accident, a vehicle accident. So thus, as it stands right now, a towing company tows a vehicle, has to clean up injurious substances. They call in a company that specializes in that. Now, the company would bill the owner of the road. The owner of the road would then bill the insurance company, and then work on getting payment from the owner of the road from the insurance company. This bill says, okay, we're going to leave out the taxpayer out of this whole deal. We're just going to allow the environmental cleanup company to bill the insurance company like it was pre-April 1, 2025. We might, obviously there's going to be cost included. We understand that. If the cost is too much, go ahead, litigate it. This does not deal with the cost of mitigation. This simply deals with allowing the environmental service company to bill the insurance. So that's why this is in NREPA. And as you look at section 16, page 5, in addition to any penal or civil fine that may be ordered for a violation of described in subsections 1 and 6, a person who violates this part is liable to the property owner and to a person who removes a vehicle under section 89022. And so this would allow that billing to happen and leave out the taxpayer.
We have Representative Hoadley.
Thank you, Mr. Chair. Thank you, Representative Green, for presenting today. Few questions, a lot to unpack in this. There seems to be a lot of maybe unintended consequences, and some of that maybe stems from looking at the original statute. It doesn't seem like it was specific to automobile wreckage, and that it was more to abuse of discharges and pollution, right?
Correct.
Neighbors, whatever. So it's concerning that we're trying to adopt that into this bill rather than going more specific to this issue. Because again, the unintended consequences, we talk about those third-party environmental response companies. What guardrails keep them from charging exorbitant or abusive and even unexpected fees when these things seem to be all over the map, from a few $100s to several $1,000s? It seems to be the Wild West on the billing on this, so
Yeah.
I have some concerns with that.
So that's a great question. Number one, why is it in this section? It's in this section of the law because this is what changed. And then as things got litigated, amazingly enough, attorneys got in and started interpreting the law and saying, okay, you don't have standing for this bill because of the NREPA law. So now we're coming back and saying, okay, that was not the intent of the NREPA law. So let's change that so that that argument is gone. Now you get into the exorbitant billing, you get into, or the perceived exorbitant billing. I don't run a environmental service company, I don't run a tow company, and I don't run insurance agency. So I can't speak firsthand to any of that. What I can say is this bill does not deal with any of that. So currently what happens is if the adjuster feels that it's improper, they say we're not paying that, and then it goes to court. That process would still continue. All this deals with is allowing the environmental service company to bill the insurance company once the vehicle's been removed. You are, in my opinion, you are correct in the concept of the Wild West. And part of that is because as environmental laws and rules and regulations are changing, the environmental service cleanup companies have to follow that, or else they are liable for it as well. And when, my understanding, when they clean up, they have an EPA or an EGLE person, third party, saying, okay, we have our little tester, no more needs to get taken out. So as regulations, the EPA, EGLE regulations increase, that puts an increased pressure on the environmental service company. That puts an increased pressure on the insurance company, which turns around and puts an increased pressure on us, the payers of the insurance. So there is a portion of our insurance that every one of us in Michigan are required to carry, which is personal liability and property damage. My understanding is this fees comes out of property damage, but again, this bill does not deal with how much is being charged. This bill does not deal with your overcharging. This bill simply says, let's leave MDOT, let's leave the city of, you put it in there, out of this whole deal, and let's let the environmental service company bill the insurance. If they don't like it, they can go to court there.
Follow up if you don't mind, Mr. Chair. Yeah, but this not touching that, doesn't that leave, again, the concern with the unintended consequences of that if we're not boxing that in on the back end? Again, you know, we've got some of the highest automobile insurance premium rates in the nation. And granted, you know, we can't always claim that the insurance companies are our friends on that, right? When they're taking that so much of our money. But it's one of those things that we reluctantly pay for and hope we never have to use, right? Insurance is a weird phenomenon in that case. But again, the unintended consequences, again, would be where those rates have to be made up on you and I and the rest of the ratepayers in this state is a major concern. These rates going up even a fraction of a percent while they're already skyrocketing.
Yeah, I would love to see that. I think you have a new bill request in. So I would love to see that new bill request.
But should that bill be before this one?
My take is no, it shouldn't be, because this law just changed. So let's remain focused and allow the courts to sort out to sort that out.
Thank you. I'm concerned with courts sorting things out though too.
So you mentioned Eagle, EPA, whoever comes out and does the testing, for the remediation. I remember testimony in front of a committee very similar to this for the sugar beets and their quality around that. And they had their complaint from the sugar beet industry was 3 different investigators came out or whatever, and they got 3 different answers on what the interpretation of the quality was. So that's another fear I have also, because we give so much power to the bureaucratic administrative functions. Also, I think that, well, let's just leave it at that right now, because I think there's going to be some other things coming up.
So I would say, Mr. Chair, the bureaucracy, we're not giving any more, with this bill, we are not giving any more regulation to the bureaucracy. It is already happening. And when you talk about some of these other situations, the sugar beets or whatever the case is, when we talk about having a state that is open for business and then we consistently try to regulate stuff out of existence, we have a fun job as legislators.
Yeah, I was just going to mention also that, sometimes people want to go to the nth degree to remediate something, just like medical companies and doctors would want to make sure that they gave every test possible so they couldn't be beholden in the future. So I think there's both sides of this that come into play.
So there is a liability component on the environmental services, but also please understand that every, from the environmental service company side, from the tow company side, from the vehicle that got damaged, they all have to have insurance. So any increase in insurance also affects the people that are trying to do the cleanup. So that's why we're just trying to keep it on the billing, on being able to bill that NREPA changed.
So is a hurricane on the Gulf Coast. Representative Scott.
Thank you. Thank you, Rep. Green, for your testimony. So this is my bill, is my law. And so when you talk about environmental cleanup and insurance and all of that, that was never part of this bill. So it seems like to me that you need to do something else, something separate. I do have concerns also. So according to the National Insurance Crime Bureau, there's been an 89% increase in predatory towing and vehicle cleanup here in Michigan, and we've seen a 31% increase. What safeguards are you planning to put in the bill to protect car owners and insurance companies from this predatory behavior?
So with, in regards to sort of 2 separate questions, right? Number one, you're right, this was never intended. And as attorneys got involved, they said, well, hey, look at that. Let's do this, okay? So while your bill was never intended to have the consequences are happening. And then inside of that, what am I planning to do with this bill to stop predatory stuff?
Right.
Well, inside of NREPA, I don't see how we can regulate the insurance companies inside of NREPA. My suggestion with this bill is let's leave the local units of government out of the billing so that the environmental services don't charge your county or don't charge your municipality. Your municipality then charges the insurance company, and when there's a conflict, the insurance company says, no, we're not paying, or we're gonna pay this minimum amount. And then all of a sudden, now there's 3 lawsuits instead of 1 lawsuit. So my suggestion is that it seems that what is the process now, or were previous, where the environmental service company charges the insurance. If the insurance doesn't like it, then the environmental service company and the insurance end up in a lawsuit. And then let the courts figure that out under the way this is written, where the property owner is responsible. As we are putting more money into our local roads, that money is going to be tied up on litigation costs. So therefore, let's just cut the taxpayer out of this and allow it be between 2 private companies.
So it sounds like to me that maybe you need a separate insurance bill, not to include it in this illegal dumping bill. That's what it sounds like to me.
I believe that there are some bills in the works. I neither support nor didn't, but there are some bills in the works that are looking at this portion of the law. Yes.
Because I'm thinking it's going to really open up the floodgates for predatory behavior.
I think anytime you're dealing with
And higher
insurance, you're
insurance
dealing with
costs.
predatory behavior.
And consequently higher insurance costs as well.
So this right now, the environmental service company is required by law, and I gave you the MCLs to start out with, that they have to do the cleanup. They have to, by law, or else they're guilty of a misdemeanor and fines. So the cleanup has to get done. The question is, are they going to get paid for it? Or are they going to bill your municipality and have your municipality's money tied up in litigation costs?
I still feel it doesn't need to be part of this illegal dumping bill. You need a separate bill to deal with the insurance codes. This
So
was
the
not
attorneys-
for environmental cleanups. It was
Yeah.
not for insurance. This was for illegal dumping across the state of Michigan.
So the attorneys applied this law in denying payment. So therefore, we are dealing with this law.
And I just want to be clear.
Leave
this
my law
te-
alone. That's what
And the
I
good
say.
law that it was.
Leave my hands off my law.
This is just I'm sorry for the cleanup law. This is just a cleanup bill for your cleanup law.
So the
It's
test,
already a cleanup bill.
the,
It's
test,
the
the
original law.
testimonies today, I have promised all entities involved, the testimony today is to air this pros and cons out, because I think every single one of us had somebody come knock on their door and sit in their desk and talk about this, and the next one comes in, they sound just as good as the other one. So now, I just said, let's have a public discussion, open forum, so that everybody's, both sides can be heard. And then if there's a paragraph change, or if it's what Representative Scott's recommending, we can figure this out after we have all this public discussion. And I'll add that the National Insurance Crime is going to testify also today, so.
And in full disclosure, I'm a politician. I reserve the right to be wrong.
And I'm a public servant and leave my law alone.
And this elected official is calling on Representative Weiss.
Oh boy, hard to follow that up. So I just want to make sure that I understand this. So I'm going to just use an example to make sure I'm understanding exactly what this bill does. So if I get into a car accident and my vehicle leaks coolant fluids out of the freeway, tow company comes out, cleans that up. Under your bill, they would not send me a bill or my insurance company a bill. They would send the tow company would send the bill directly to the insurance company, and I would never see it. Is that correct for the cost of the cleanup?
I would add another layer in
Okay.
that now your coolant got into a drain that drains the city of Detroit. Okay, or I'm sorry bringing the name of a city in. And so there's a cleanup that has to happen because there's now environmentally. I would guess the majority of times that we're dealing with exorbitant amounts is not because we have a Honda Civic. It's because we have a Peterbilt semi,
Sure.
et cetera, that we're getting into some pretty major cleanups. But what would happen now is instead of you getting the bill, the municipality that owns the road, the property owner, would get the bill for the cleanup.
So my insurance would not be liable. The municipality's insurance would be liable?
The environmental services company has to bill your municipality. Your municipality would bill the insurance company. leaving.
Their insurance company, is that?
No, your insurance company, because
Okay.
it's your car.
Okay. But I wouldn't see any of that as the vehicle owner. Is that correct?
I would probably, again, I'm not an expert in on either side of this. I would probably say you're correct that you would probably never, but your tax dollars go to your local municipality that is going to be tied up in court.
Yeah, the reason why I asked that is because if there were, for example, let's say there was a predatory situation where a company said, oh, you dumped a Peterbilt truck worth of fluids into, your Honda Civic dumped that into the drain, and that obviously didn't happen. And I never saw that as a consumer, but suddenly my insurance rates go up. I have concerns about that from the consumer protection point of view, where like I do feel like the consumer should be part of this and at least being able to monitor what's happening, because ultimately they're going to have to bear the cost of increased insurance rates.
Yep. Yeah, so I mean that is a very good point. And I believe these environmental service companies are either called out by a tow company because they've been called out by the police to tow the vehicle and they are responsible for cleaning it up.
Okay.
Or they've been called out by the emergency manager, what the incident manager there. So it's not like there may be instances of very bad actors driving around in their truck going, oh, look, there might be some gas over there. I'm going to clean that up and bill somebody. These environmental service companies are dispatched by either the tow company that's there on scene removing the vehicle going, I don't have enough kitty litter to clean this up, or the emergency response incident commander. So, I mean, that is, obviously we can go down a lot of what ifs, but that's many of the questions that I've tried to figure through as well.
I understand. I just know this is a cleanup bill, right? And we don't want another cleanup bill for another cleanup bill for another cleanup bill too. We want to make sure that we're dealing with unintended consequences in the front end if we can.
Yep.
Thank you.
Oh, geez, what am I going to do for the next 6 years? Representative Johnson.
Thank you, Mr. Chair. Thank you, Rep. Green. I feel the pain of the municipalities who have been burdened with high bills. My fire departments came to me recently and said, if we pay this, we've used up our remainder budget for the year. I get it. But what is the monetary penalty for insurance fraud with inflated expenses and cleanup from these environmental companies? We know this is going to happen. Do we have it built into the bill that it's going to be a really high penalty, so there's a disincentive to fraud the process here?
I don't know the answer to that. This bill does not deal with that. I'm going to guess that inside of our code somewhere we have a penalty for insurance fraud. My understanding is if a tow company does not clean it up, that is a civil infraction or a misdemeanor for the tower to not remove all glass and injurious substances from the incident scene. So when we're talking about the insurance fraud, we're talking about a different section of law that I'm sorry, I'm just not up to speed on.
This is part two or part B of one question. I think without the teeth in it, this is gonna leave us wide open for a lot of fraud. So I'd like to suggest that if we're really going to pass something like this, we got to have a steep penalty. One of the reasons our courts are so full of, procedural, lawsuits left and right is the fraud, the lying, the lack of integrity across the board. And if we don't shore that up right at the get-go, we're going to have enormous problems and 5 times the amount of lawsuits.
Yeah.
Thanks.
So again, this bill isn't trying to solve all the problems of the towing, insurance, environmental mitigation. We're trying to move this back to pre-April 1, 2025, allowing the service companies to bill, and then I'm sure you'll hear from others that are going to talk about whatever, that there's major problems. I'm assuming that they're ferreting this stuff out. I'm assuming that they are denying coverages or denying charges. I'm assuming that it's going to court. So I'm not saying the system that we currently have is perfect, but what I am trying to move is that we go back to a pre-April 1, 2025 and allow this companies to bill the insurance. Not saying that the insurance must pay, just allowing the bill to go through. Then from there, they can figure out, is this fraud, is this abuse, is this waste, what is it? And then keep the taxpayer out of the negotiation.
Representative Preston.
Thank you, Chair. Thank you, Rep. Green. I've been an incident commander on several major spills, minor spills on the highway. In fact, the bulk of what we do are PIAs, personal injury accidents. This stuff is largely handled, 100% handled by the fire departments. We're charged with making sure that the road is ready to be opened before it is opened. We're usually the ones that are spreading out the kitty litter. The shoulders are riddled with VOCs up and down the highway. When you do adopt a highway and we're picking up garbage, we're seeing incidental spills up and down the highway. There's several questions that I have regarding this, but I think the unintended consequences on this are far and wide. I don't really see how this is a technical fix to Rep. Scott's bill. It seems like it's more of a policy change. I need an explanation on that. And I need an explanation as to how this is not going to be weaponized, because if you have an accident in a section of road where there was a previously undisclosed VOC release, and then all of a sudden that person through soil analysis gets looped into that VOC release that had nothing to do with them, you have no idea how big that release was. It could be 100 gallons of contaminated soil that accidentally gets dropped on a person that just happened to have an accident at that spot. Because literally, when you go up and down the road, especially on gravel shoulders, you got to remember every car that travels that road is continually releasing VOCs onto that road. And then every time it rains, that all runs off into the gravel. So you literally have a hazmat contamination all the way up and down every shoulder of every highway that has gravel. So I think the unintended consequences on this, especially the insurance premiums and the possible cronyism that can come out of this, I've just really got a lot of concerns. But I would like to know where the technical fix with the rep's bill is, because this really just looks like a change in policy.
So I would, in answer to your, yes, we have some major issues. I'm not sure if your issues are with the cleanup people or with the EPA and Eagle that are doing the testing.
No, Eagle is always there as a partner. But like I said,
What I'm saying is they're the ones saying you have to remove that shovel. You have to remove that. You have to remove that. The environmental service people are there to do what Eagle and EPA says they have to clean up.
Yeah, but when they come in and they see, oh, there's a release, we want to test that soil, what's Eagle going to say? No, they're going to test that soil. Oh, yeah, that's got to be remediated as well. There's just a lot of unintended stuff that could happen out of this.
Okay, so Section 16, page 5, Section 16, the line 6, if you're looking at my bill that I have in front of me, says, and to a person who removes a vehicle. So that goes back to the tower that removes the vehicle. So that is allowable to the person who removes the vehicle. That's the technical fix. The rest of the illegal dumping or the littering cleanup, falls onto the property owner. This would say, person who violates this part is liable to the property owner and to a person who removes the vehicle. So that's the technical fix. It's not talking about a 5-gallon bucket. It's not talking about, a case of oil that fell out of somebody's truck. It's talking about the person who removes the vehicle.
So it was added for the property owner, but it wasn't eliminated anywhere else.
That's the technical fix. That we're keeping the spirit of the law, that in the illegal dumping and the littering components, that they are the property owner's responsible. When we're looking at when a vehicle has to be removed, the person who removes, and to a person who removes the vehicle. So it's, if we can use the horrible phrase, a carve-out. Everything else stays with the spirit of the law unless you're dealing with a towed vehicle.
I would just offer, I've been on a lot of these and I just have not run into any issues on this. And our largest one was a fully loaded petroleum tanker holding diesel and unleaded gasoline that ruptured. So
Yep.
and
And you probably would not have dealt with it because this is a contract between the company, the cleanup company, and the insurance. Your whole goal is to get that road reopened as the incident commander. So then on the backside, how does that cleanup company get paid? Does it come from the property owner or does it come from the insurance company?
Move on to Representative Wirtz.
Thank you, Chair. Okay, based on what you just said, I'm adding one more question. So are you saying that currently the cleanup companies aren't getting paid by the insurance companies?
Currently, some of the attorneys and adjusters have used this clause to deny payment. Some have. It's sort of hit and miss. Some have, some haven't. But this is to clarify that the tow companies are allowed to do their job and get paid for doing their job that they are required to do under our law.
But is the tow company is not required to be the cleanup company, nor are they usually, if it's an environmental spill.
Correct. So you're going to hear from others that you might be able to ask this technical question. They are the responsible party to clean up. Okay.
Well,
But they may call in a company to actually do the cleanup. As Rep. Preston talked about, you have a tanker that dumps a lot of fuel. Well, the tow truck driver has 50 pounds of kitty litter. If that, he's not going to clean up. He's not going to be. So he's going to say, "This job is bigger than me. I need to call in somebody else." So I think you're gonna hear from somebody that is boots on the ground.
well, the towing company is just required to get the vehicle out of the roadway.
According to, just a second. According to MCL 257-618A 5 and 7 and MCL 324.89202 Section 2, that is, they are responsible to remove the vehicle and any glass or injurious substance.
What does injurious substance mean?
The EPA has defined injurious substance as the list.
I find that interesting, and maybe because you're saying this changed April 5th, but my son was involved in an accident a year ago this week, actually. Young driver pulled out in front of him, blew a stop sign. He swerved to miss and rolled a semi, which was fully loaded with fuel. And I arrived on the scene, and the first responders gave me the number to call to have environmental cleanup come out. The tow truck company, the only thing they did was haul the semi away. The fire, they provided the sand and all the cleanup, and then I made the contact with the environmental company that was involved with the cleanup. So I guess my question is, you're saying that's all changed since April 1st, and could you provide examples of companies that are not receiving payment on the cleanup?
I believe you'll hear from a company, at least one company here, in short order.
Okay, thank you.
We'll return to Representative Scott.
I'll make it really brief. So initially, this was for residential areas and dumping, not roadways, like you're saying, and highways. I guess my question is, what is the real reason why you're bringing this? Was it a constituent that brought this to you?
Yeah, a constituent, owner of a company, it's a constituent, brought it up to me that the attorneys were in a back and forth, and the opposition's attorneys were invoking this law.
Does he own a towing company?
He owns an environmental service company. He's probably part owner in a towing company. But you'll be able to ask him. I'm assuming that there's questions.
Good. Okay, great. Thank you.
And Representative Preston, you have a follow-up? Very good. We're going to move along to, thank you, Representative Green. We're going to move along to Mr. Jimmy Johnson with Michigan Associated Counties, speak on the bill. Mr. Johnson, I'm going to take it easy on you in front of my committee. It's good to see you. Good to see you too. In this role.
On the other side of the table now. Well, Chair Martin, members of the committee, my name is Jimmy Johnson. I'm a governmental affairs specialist with the Michigan Association of Counties. Appreciate the opportunity to be able to come here and testify in support of House Bill 4411. When a spill happens, whether it's sawdust on oil or it's major like a semi-truck crash, counties are going to rely on environmental responders to act fast. For instance, last year in Gratiot County, there was a 2-vehicle crash which spilled 80 gallons of diesel on M46, which shut down the road for right around 9 hours while this cleanup had continued. Under the current law, this cleanup company couldn't directly recover its costs, forcing the county to manage reimbursement disputes and absorb risks. House Bill 4411 restores those cost recovery rights to qualified responders, protecting the counties from financial exposure, ensuring swift action, and keeping capable providers in the fields. The Michigan Association of Counties supports this fix, and we urge you to do the same. I'm happy to answer any questions as well.
Okay, don't counties have liability insurance? And if there's an issue, then wouldn't liability insurance kick in if it defaults back to them or a township or municipality?
So my understanding of this, and there will be experts that come on afterwards. So my understanding of how this works is that, let's say that a car has a crash and then there's a spill, and then environmental cleanup has to come out. It's on a county road. The counties at that point would be fronting those first costs until the individual's insurance provider is able to approve those environmental cleanup costs, and then it would come back. So essentially where we support this is that we don't have to be the middleman in here. We're not going to be chasing the insurance payments. We just want the individual and the insurance companies to figure that out. And then, we're not calling balls and strikes essentially in between the dispute process between the environmental cleanup and the individual.
Do you have an example of where this has happened?
I don't have one off the top of my head, no. I'd be more than happy to provide one for you.
Looks good. Thank you, Mr. Johnson.
Thank you.
Now via Zoom, we have Craig Speech with National Insurance Crime Bureau in opposition to the bill. Can we bring Mr. Speech up and see if he's there?
Yeah. Good afternoon. My name is Craig Suppich, Director of Strategy Policy and Government Affairs with the National Insurance Crime Bureau. Chair, members of the committee, thank you for the opportunity to discuss our opposition to House Bill 4411, which establishes provisions that would incentivize the commission of insurance fraud and negatively impact consumers. We all pay for insurance fraud. The National Insurance Crime Bureau, NICB, is a national century-old nonprofit organization supported by approximately 1,200 property and casualty insurance companies and rental car providers, including many who write business in Michigan. Working hand in hand with our member companies and Michigan law enforcement, we help to detect, prevent, and deter insurance crimes. Vehicle collisions often cause significant strain on victims. In addition to dealing with serious injuries that may result, the victims must often report to law enforcement and file insurance claims. Handling these ongoing medical issues, managing follow-up appointments, with medical providers, insurance carriers, and law enforcement agencies providing this additional written material that may be required, and finding reputable vehicle repair shops all pose a significant burden on victims as they deal with the after effects of a collision. This high-stress situation creates the perfect opportunity for unscrupulous towing companies or secondary cleanup companies to exploit accident victims. Oftentimes, we see these owned by the same ownership structures. While most towers are upstanding small business owners, there are predatory towers or cleanup companies that often take advantage of the confusion at the accident scene or after the fact by grossly inflating invoices or falsely claiming various services were rendered at the scene. NICB has seen examples of highway remediation companies charging accident victims exorbitant fees, sometimes as high as $17,000 for a small two-vehicle collision to clean up coolant. In some of these situations, the predatory towers essentially hold these cars hostages until the fees paid or lawsuits are filed against the vehicle owner. Nationally, NICB has seen an 89% increase in predatory towing and affiliated claims in the last 3 years. And during the same period, Michigan has experienced a 31% increase and is ranked in the top 10 states per capita. Both Detroit and the suburb of Taylor are ranked in the top 15 cities nationally for total predatory towing claims. Additionally, one of the growing reasons for these predatory towing claim submissions is for inflated invoices and false claims for rendered services for highway remediation services. Michigan's waterways and natural beauty are a treasured resource for residents, and unfortunately, House Bill 4411 creates an incentive for insurance fraud by encouraging these unscrupulous towing and highway remediation companies to inflate expenses for debris and waste cleanup and then threaten litigation unless those demands are met. We all pay for insurance fraud through higher insurance premiums. Accordingly, we ask that you oppose House Bill 4411, and thank you for scheduling this hearing and considering our views. I'm happy to answer any questions.
Thank you, Mr. Sevick. I'm curious, and I don't think we want to go there, but is there any standardization of size, type of fluids, type of whatever is has to be cleaned up? Is there any? I know we don't want to go down the road of medical coding type thing, but is there a standardized payment or something that somebody could logically look at and say a size of square feet, so much soil removed or whatever has to be done, dams put in to prevent going into gutters, vacuuming things out. Is there any standardized billing for anything like that?
Not to my knowledge at the time. This has been a really evolving, issue over the last several years. So that may be something that, we see develop, in the coming future. But, right now it's just trying to get after, a lot of these inflated invoices, and just to give it, an example for, some of these services, we've got reported claims where you'll have the towing company will submit an invoice to the insurance carrier saying that they provided $300 of an absorbent material, kitty litter on whatever the spill fluids were, and there's an invoice for that. And then you'll have the hazmat company come in 2 weeks later and submit an invoice for $9,000, for the same services that were rendered. And, there's no proof that, these services were provided. The itemization of these charges is not always the most clear. And that one example, that was for a single vehicle accident, and you have a $9,000 bill.
Thank you. Representative Scott?
Thank you. Thank you for your testimony. So you mentioned something about a $17,000 and the driver couldn't get their car back. So these costs are being put on the owner of the car?
Yes, it's to file, it's lawsuits against the owner of the car and the insurance provider. So the bill oftentimes gets sent to the vehicle owner, who then has to contact their insurance provider and navigate this entire, scary process of what do I do about this massive bill for services I don't even know were provided.
And if the insurance company decides not to pay, so the consumer or the owner of the car has to pay it in order to get their car back. Otherwise, they just don't get their car. Is that correct?
Correct. And we've seen other situations, and that's for the driver who's fortunate to have, the comprehensive coverage. A lot of drivers will only have a liability policy. We've also seen bills, it's the same $9,000 cleanup, it's a liability-only vehicle. So the owner in that situation was forced to just give up their vehicle to the company, to the hazardous waste company. They weren't able to retrieve that, though. If they could have, got it to a body shop, potentially they could have had it repaired and back out on the roadways. But instead, they lost their vehicle.
Thank you. Thank you so much.
Representative McFall, or Vice Chair McFall?
Thank you, Chair. This might have been a question that I probably should have asked the bill sponsor, but I'm not sure. Do we know where the Department of Insurance and Financial Services is on any of this? Because I'm not seeing any, I'd like to know some sort of stats for complaints or any of that sort of information. Because I would imagine that they have had people complain if this is a problem. So sorry, the question just popped into my head. So I don't know. I don't know if that's for him, if he could answer something along those lines, or if the Rep Green.
If there's no further questions, we can bring Rep Green back up.
Oh, okay. Thanks.
I could answer that to an
You
extent.
can take a stab at it? Good.
These questionable claims that we're reviewing, they're submitted by our providers, our members to NICB, which is, also reported then to DIF's, fraud investigation unit. We work hand in hand with them to investigate insurance fraud, so they would be aware of these instances as well.
Well, thank you very much. Do you need Representative Green to explain anything?
I mean, if he has some information, is DIFS testifying or anything? Oh, okay.
Thank you, Mr. Sepik.
Thank you, Mr. Chair.
Just in case Representative Green raises something, we'll see if we need a rebuttal.
My understanding is DIFS is not the correct agency for this. The lead agency is Eagle, and Eagle is neutral.
But wouldn't the complaints go through DIFS, though? That wouldn't go through Eagle, because if you have a problem with getting your car back, like the example, so I'm just curious what DIFS. I mean, I know that the lead agency, but it seems like they should have something involved in this.
I don't disagree with your assertion.
All right. Thanks.
Okay, Mr. Sepik, that's all we have. No more questions for NICB. I'm going to read in some cards now. There's several. Not wishing to speak, opposing the bill, Dyke Van Coovering from Insurance Alliance of Michigan. Not wishing to speak, opposing the bill, Andrew Vermeesh from Farm Bureau. Not wishing to speak, opposing the bill, Robert Binnick from Enterprise Leasing Company of Detroit. Not wishing to speak, opposing the bill, Joe Roth, American Property Casualty Insurance Association. Not wishing to speak, supporting the bill, Ed Noyle from County Road Association. Not wishing to speak, supporting the bill, Judy Allen, Michigan Township Association. Not wishing to speak, supporting the bill, Ken Moran, Michigan Towing Association. And not wishing to speak, supporting the bill, Dave Hodkins from the Michigan Municipal League. We have one more testimony. We're going to call up Mr. T.J. Craven from the Michigan Spill Response. Mr. Craven?
This is the first time for me, Mike, right here.
Yep.
Okay, excellent.
And if you're lucky, it's the last time.
Yeah, there you go. Well, I must say I'm quite interested in the fact that everyone is very interested in what's going on here. It has to be shaken out. I guess I should introduce myself first. My name is T.J. Craven. I am an attorney. Sorry. And I represent companies, environmental companies, in claims like this. I have a very small niche practice where I handle these claims, and I see them once a week. Genesee County, Lapeer County, Oakland County. In fact, I was in front of Judge Newblatt last week on this same issue. The first thing I find kind of interesting about this is that the NREPA mentions three parties in Rep. Scott's bill. Three parties are mentioned in NREPA. The first is the litterer, the responsible party. It's very clear under the statute that the responsible party has to, they can't litter, okay, first of all, and injurious substances have to be removed. That's the first party in NREPA. The second party in NREPA is the government. The government has a right to recoup the costs of remediating substances, okay? Excuse me, there's four. There's a property owner, okay? There's the property owner. They have a right to recoup those costs. And the fourth party who is mentioned is the person who removes a vehicle from the scene of an accident. So four parties: the responsible party, the government, the property owner, and subsequently the tower, whoever removes a vehicle. Nowhere in the statute does it mention insurance companies. It doesn't. It boggles me. It's not mentioned. And Rep. Scott's nodding. She goes, it's not mentioned. And yet, those opposed to this bill are the insurance companies. Well, I suppose I'll explain to you why that is. Before this cleanup portion, pun intended, to NREPA was established, the littering statute only mentioned two things. It mentioned if you litter, you got to clean it up. You can't litter, okay? The second was if you remove a vehicle, you have to pick up all glass and injurious substances. That's under 3248202. That bill had no teeth. That law had no teeth. And Rep. Scott, you would agree that law had no teeth at that point. What Rep. Scott did was say, look, there are consequences if you don't do what you're supposed to do, if you don't clean it up. There are consequences. And that list of consequences is extensive. Misdemeanor, $1,000 fine the first time, $2,500 the second time, $5,000, and then misdemeanor fines for all of that. And what does that apply to? Who do those fines apply to? Who do those misdemeanors apply to? They apply to two people in the littering statute. First, the litterer, and second, whoever removes that vehicle from the scene of the accident. So my client, let's do an example here. My client goes out to the scene of an accident, and there's a substantial diesel fuel spill. It's 2 o'clock in the morning. Fire department's out there. They don't see it, with respected Rep. Preston. Fire department's out there. They're overworked. Most of them are volunteer now, which is kind of outrageous. My cousin works for Alba Township's fire department, and they're part-time. So the fire department goes out, and they're on the scene. They're leading on the scene, and the towing company sees this diesel fuel, this 50 gallons or 100 gallons, whatever, of diesel fuel in the ditch, and they don't report it. They say, look, we can't get paid on it. We're not going to get paid on it. We're not going to report it. Okay? They go back around their day. 3 or 4 days later, probably not, a week later, they get a letter from the Attorney General. You are being sued under MCL 3248202 because you did not remove all glass and injurious substances. You're guilty of a misdemeanor, and you have a $1,000 fine. This is the first thing that happens, because that's what the bill does. That's what this law does, is it gives there are repercussions for not cleaning up spills. On one, the responsible party, and two, who's ever removing the vehicle. The only issue is those duties are propounded on companies, on whoever removes a vehicle. Those duties are propounded on the towing companies or spill companies or whatever. They have to do it. There's no ifs, ands, or buts. Under this bill, they have to clean up the glass and other injurious substances, okay? But there's no way for them to recoup those costs. None. Now, we were talking earlier, and our friends from Friends, as I litigate against insurance companies, which that's the way it turns out most of the time, our friends from the insurance companies had specified that this bill would allow for predatory towing. Predatory towing and towing is dealt with under MCL 257.252. That is our towing, non-consensual towing statute in the state of Michigan. So if you get in a wreck and you're at the hospital, the police call a towing company and they come out and handle the wreck. okay? That statute deals with predatory towing. There are repercussions for predatory towing actions, and it specifically says that in the act. And if you have a vehicle that the towing company's not letting you get, you're going to be criminally prosecuted. So those are dealt with under the Towing Act. Unfortunately, this law specifies that towing companies have to remove all glass and other injurious substances. There's no disagreeing with that. There's no fighting that. They have to do it unless the legislature decides that no, they don't have to do it anymore. They have to do it. When I walk out of here, if you guys all say, nope, pound sand, we're not taking up this bill for cost recovery, one thing doesn't change. The companies have to clean it up. They have to. There's no other duty there. There's no other duty under this. If it's spilled, it has to be cleaned up. This bill simply says, look, we have a right to clean up. Because we have a right to clean it up, like the property owner, we have a right to seek compensation for that. And where the insurance companies are involved as an ancillary entity. They're involved only on the back end for purposes of payment on these issues. I pretty much went all off script based on everything that I heard from everybody up here, which is kind of what I do at the Court of Appeals. But I wanted to make sure that I could address those points of concern. But I would love to have some questions.
Thank you, Mr. Craven. We have Representative Hoadley with a question.
Yes.
Thank you, Mr. Chair. Thank you for your testimony.
Thank you.
In your testimony, you'd stated that the cleanup is mandatory
Yes.
by this company, but then you went on to say that there was absolutely zero way of recovering the cost.
So,
and I guess what I'd say is earlier testimony stated that this would have to be settled in the courts as the remediation, and quite frankly, that's what you do.
Yep.
Correct?
Yes.
So there is a method. We're just talking about who you're suing, correct?
Great question. We lack standing currently. So, not in technical terms, we lack standing under this statute. So prior, when I litigated these cases before Rep. Scott's bill was passed into law, and it simply said, if you remove a vehicle, you have to clean up all glass and other injurious substances. And judges went, excellent, because you have a duty to do something, you have an affirmative duty to do something, you therefore have a right to cost collection on those costs. Okay, you have a right to that. Now, the exclusive remedies, for a lack of a better term, under the statute specifies that only the state and the property owner can seek those costs. But it still says that the towing companies are responsible for cleaning up all glass and other injurious substances. There's another section, 252.618, that specifies, it's MCL 257.618, that specifies that the towing companies have to remove, quote, all personal property from the scene of an accident. We technically fall under that statute as far as cost recovery goes, but the courts are still somewhat out on that. Hopefully that answers your question. It seems kind of muddled, but.
Yeah. Thank you. It was a little muddled. But,
Yep.
Anyway, so I guess who do you sue now? And how many of these cases are you taking on? How big of an issue is this with these companies not recovering this cost? And again, who are you?
Well,
this is what you do. Who are you going after?
So, interestingly enough, it's almost exclusively paid under no-fault benefits, under MCL 500.3121, which is the No-Fault Act. However, the Michigan No-Fault Act specifies that it doesn't say it explicitly. It says anyone who has property that is damaged resultant from an accident shall pay the reasonable cost of repair and replacement minus depreciation. The question is, who's a person who's damaged? Is a company that cleans up a spill on the highway a person who's damaged or not? As far as before the statute was enacted, I have examples here. I have examples of instances where I worked with insurance companies to determine what was reasonable. What are the reasonable costs? If you don't think this is reasonable, why is it? And insurance companies paid, and they said, look, we know it had to be cleaned up. Let's go through the costs. Now it's, you can't collect on these costs. There's no, you can't collect on them. There's no reason for you to collect on these costs. So the bill has, or excuse me, the law that was enacted has changed that ability.
We have a couple more questions coming up. I want to remind people it's 10 after 1.
Yep.
Representative Wooden.
Thank you, Chair, and thank you for your testimony. Just so I can understand, you, I think in your previous answer, you suggested or you said that there was another statute that you were typically filing these suits under. Did I hear that correctly?
So if you're familiar with any kind of lawyering, it's the idea of throwing it at the wall and seeing what sticks, especially with standing issues. So generally, these cases are filed under Michigan No Fault MCL 500.3121. It's also filed under MCL 618 or 257.618. That basically say that you have to clean up personal property or whatever from the scene of an accident. So they're trifurcated complaints. It's one under NREPA, one under No Fault, and one under Michigan's vehicle code.
And, you know, I imagine you don't have every case that you've argued memorized off the top of your head, but ballpark, well, for starters, how long have you been practicing, just for my own?
Well, my bar card's still pretty warm, so it's off the printer. No, 3 years.
3 years?
Yep.
And so in your 3 years, how many cases were thrown out on standing prior to this law being enacted, and how many were thrown out on standing on NREPA?
None have been thrown out on standing.
Okay.
Excuse me, none prior to the enactment have been thrown out on standing. Right now, the question, I believe, is before the Court of Appeals. Not me personally, it's another firm handling it. But as far as those claims being thrown out for lack of standing, it has been. And in one circumstance, there was a case that I just had where a vehicle went off the road through the highway onto someone's property and spilled about 150 gallons of diesel fuel. And the person was like, I can't afford to clean this up. You know, can Michigan Spill Response, who's a client of mine, can you guys clean this up? And we said, yeah, sure, that's fine. You know, give us agency to file a claim on your behalf through NREPA. And the courts are going, well, wait a second. Only the property owner can file these claims under NREPA, not a third-party company. So the court's basically waffling between the idea that, well, wait, no, you have to file, the property owner, you have to pay for the remediation, you have to pay all these costs, and then you can file a case if you want to. And that's my theory is, since NREPA, unintended circumstances with insurance companies, but boy, oh boy, have they used it as a shield. I mean, this is their, NREPA, this section is a shield for non-payment now. At least that's, from my experience, what I have seen. And I've got 5 of these cases active right now.
5 active cases, and typically how many cases like this are you working on in a given year?
Between that probably 5 to 7. This is the most I've handled at one time. 9 times out of 10, these get shaken out as settlements. But when they have to go, they have to go.
Thank you.
Yeah.
Okay, Representative Warts.
Okay, just to clarify, so who do you represent? You represent the towing company or the cleanup company?
So technically, it's the towing company who's responsible for cleaning up the incident scene. So under NREPA, it would technically be the towing company who's responsible. However, they do give agency to third parties if the spill goes beyond what their capacity is.
So then why can't the towing company, why aren't they just billing insurance directly?
They do. And then the claims are denied. I work a lot of times when the claims are filed with insurance companies, I work with insurance companies to flesh out these issues, and sometimes the claims are just flat out denied, and then we have to go to court.
And how many of those have you had since this law change went into effect?
3.
3.
Yep.
For the towing company,
Yes.
not the cleanup company.
I guess I don't understand your question, because they're it's the same. At least when a case is filed, it's the same entity, but it's 3 altogether.
I guess I'm confused as to who you're exactly representing. Is it the towing or the cleaning? You're saying it's both. So
Under NREPA, it specifies that the towing company is responsible to clean up, the glass and other injurious substances. So technically, it's their responsibility. So if they call out a third party to clean up this spill, and the bill is $45,000, on a big tanker, technically the towing company is responsible for those costs. So at that point, they're the subrogee for the cleanup company. So they're responsible because they're responsible for those costs, and they called out the cleanup company as is their responsibility. I would then represent the towing company as basically the subrogee of the cleanup.
So how would this bill change save any of us money?
Save the consumer money. How would it save the consumer money? Well, as it would stay right now, if a tanker went into, let's say, my front yard and spilled on my property, I would have to call out a cleanup company to clean up that spill, and then I would have to seek compensation from the responsible party. And so I would have to, as a consumer, I would have to front whatever the cost is for the cleanup, and then hope that I get compensated by the responsible party. Under this bill, it's the responsibility of it's no longer the county or the municipality or the state of Michigan who pays. It would be the company who does the cleanup takes on those costs themselves, and they go after the responsible party or their insurer directly. So no constituent would be paying for damage to their property that was caused by a third party.
I do have a message from Department of Eagle. They are taking no position. They're still evaluating the bill and asking for concerns. So I just want everybody to know that Department of Eagle did weigh in. That being all, thank you very much, Mr. Craven.
Thank you very much.
Representative Vanderwall moves to excuse absent members. There are none. Yeah, there is. Oh, yeah, that's right. Representative Arvin. We are planning to meet next week, which is September 10th. There being no further business for the committee will stand adjourned.